In this video I want to take a look at an interesting case there recently, and it's to do with what's known as duplicate or parallel proceedings. The starting point for this case, and I think it's an interesting one, it's decided by the WRC, the Workplace Relations Commission, but the starting point for this case is the central acceptance, widely accepted position as espoused by the High Court in Cunningham versus Intel, in which the High Court held all matters and issues arising from the same set of facts or circumstances must be litigated in the one set of proceedings. So all issues and matters arising from the same facts, the same circumstances must be litigated in one set of proceedings. And that's a well-established or well-accepted principle. However, recently there was a case involving a former HR manager who brought a claim to the WRC under the Maternity Protection Act 1994 and the Employment Equality Act 1998. And the background is the HR manager in question, the employee, returned to work after maternity leave and discovered or claimed that her position was fundamentally changed. And so she brought a claim to the WRC under the two acts, the Maternity Protection Act 1994 and the Employment Equality Act 1998. The employer then and the employer had a well-known, well-recognised firm of solicitors and counsel. They made a preliminary issue and basically said that the complainant could not pursue claims under the two different acts arising from the same set of facts. And they relied on a Labour Court case, and that Labour Court in turn relied on the jurisprudence of the High Court in the Cunningham case, the Cunningham and Intel case to which I've referred. Now, the adjudicator then had a decision to make. Could the adjudicator decide this case under two different acts, the two different claims, or was the adjudicator obliged to tell the complainant, look, you must choose one or the other? The adjudicator noted the Labour Court case that the solicitor and the barrister for the employer put forward. And they noted in that particular case that the employee in question had brought a claim originally to the Rights Commissioner under, I think, the Maternity Protection Act or the Employment Equality Act, and then sought to bring a claim arising from the same set of circumstances or facts to the Labour Court. And the Labour Court understandably referred to the High Court position and said the same set of facts, same set of circumstances, all issues and matters arising from the same set of facts must be litigated in one hearing. You already had a day out at the WRC. It was decided, or at the Rights Commissioner Service. It was decided at the Rights Commissioner Service, and therefore this matter is raised judicata. In other words, it has been decided already. However, in this case involving the HR manager and the employer, the adjudicator found or determined that she could actually, or he could, hear the claim or both claims under the two different acts. And the reason for that is because both claims would be heard here at the one sitting at the WRC, and neither of the claims had been heard or adjudicated upon before, and therefore was not raised judicata. It's an interesting decision. The adjudicator then went on to hear the case and made awards under both acts. So the adjudicator awarded €9,547. That's 6 weeks remuneration under the Maternity Protection Act, but then awarded €41,370 under the Employment Equality Act. In short, the employee was awarded €50,917 under the two different acts. And as I say, the employer had a leading firm of solicitors and a leading barrister, senior counsel, I think, very experienced and knowledgeable about employment law, but nevertheless the employee won the case. The facts were decided in her favour, and she was awarded over 50 grand. It's an interesting case, and it makes a fine distinction in terms of res judicata and all matters and issues arising from the same set of facts or circumstances must be litigated in the one set of proceedings. But it does distinguish between this type of case and the other type of case the Labour Court had previously determined, where the employee had a day out already with the Rights Commissioner service and then went to get another nibble, another bite of the cherry at the Labour Court. And in that situation, it was held to be res judicata and couldn't be heard by the Labour Court and wouldn't be heard by the Labour Court. However, in this case, the employee was entitled or allowed to bring both claims arising from the same set of circumstances, and both claims obviously popped up under two different acts, the Maternity Protection Act and the Employment Equality Act. Now, if you want to read a blog post about this particular case, and if you want to read the full decision, it's worth a look at. You can do so on my website, employmentrightsIreland.com. And if you just do a search on the site for parallel proceedings parallel proceedings, WRC decides both Maternity Protection Act and Employment Equality Act claims can be pursued. It's worth a look. If you find this video useful, then I would appreciate if you give it the thumbs up down below. Thanks for watching.